Hello, hello everybody. Myself Dr. B.S. Patil. Today I am making a presentation on behalf of my colleague Kim Kuto. The content writer of this module 1 is Kim Kuto and I am making a presentation on her behalf. The module 1 is relating to access to justice and analyzing of its concept, history and evolution. And in today's presentation, I will be going briefly I will be going through the meaning of justice, and when we go through the meaning, it has got two components, traditional as well as a modern view over the meaning. Then from justice we move on to access to justice, that is what the main topic of today's discussion, and here again we are having two components, traditional as well as modern view. And finally, I end my presentation with a discussion on the mechanisms to ensure this access to justice. So, to start with today's presentation, the object behind this presentation is to make you understand the concept of justice and its significance, the conceptual analysis and the framework, and identify and recognize various mechanisms which ensure such access to justice. To understand the concept of justice, it is necessary to know the concept of law. The law and justice are so closely related with each other that they are as good as the two sides of a same coin. The justice and the law, the relationship, again I want to quote another example, that it is like a pen and an ink. A pen without ink is of no use. Similarly, a ink without pen may not be put to proper use. So, similarly, law and justice has to be kept together. So, one of the jurists has mentioned very beautifully that law without justice is blind and a justice without law is lame. So, therefore, in the beginning I just want to spend some time understanding what is law, but as the topic is connected with the justice and access to justice, I may not be able to go through with the definition of law elaborately. So, in the beginning, what is law and what is justice is going to be our first task to clarify. So, what is law? So, there have been many jurists working on this concept of law, and many jurists have also come up with various definitions of law, but one final conclusion that we can draw is that law, justice, these are the concepts which cannot be explained or defined from one's point of view. They are two broader concepts, but nonetheless the efforts of these philosophers have not gone waste, as it is you may recall the names, the philosophers Aristotle, Saint Thomas Aquinas, Roscoe, Kelsen. These jurists have come up with their own definitions of law, and these definitions has brought us, may not be a complete foolproof definition, but definitely it has brought a lot of clarification in understanding the law. In a similar vein, it is also necessary for us to know the definition of justice, and the definition of justice differ from person to person and definitely differs from time to time and culture to culture, and there is no acceptable definition of justice that exists in this world. To explain my point of view, let me take up an example of, say, moral policing. Moral policing is being defined and it is been considered to be a wrong by many of the legal luminaries, but many of the traditionalists find moral policing as the necessary evil which has to exist in this society. To take an example from one culture to another culture, there is a concept called as white man's burden. Now, this white man's burden is the burden which an European carried with him wherever he went to colonize the world. So, the colonizer thought that there is uncivilization exists in rest of the world other than Europe, and he is under the burden to civilize the rest of the world. So, that is his justification for the act of bringing in civilization, but wherein the other parts of the world, where they try to impose their views on this, the culture, the traditionalists felt that it is an attack on their existence. So, this again led to two different views. So, justice according to white man is different, and justice according to the traditionals and the locals is different. So, this conflict of views do exist while defining the definition. So, therefore, what we can do is, what we can finally conclude is, justice is a concept which is influenced by politics, ideology, religion, ethics, culture, and etc. So, therefore, rather than looking into what is justice, let us look into the justice as we understand. So, understanding of justice is of two kinds. There is a traditional view to justice, as well as there is a modern view to justice. What traditionally we look at justice? As Plato has mentioned, justice is performing fair and just actions, giving each person their due, sense of being fair, sense of being equal, moral and impartial, and treating all of them equally is justice. So, traditionally justice is a behavioral pattern between the two individuals. So, whenever I treat other person fairly, equitably and impartially, I tend to do justice. So, justice in Indian context, justice takes over the role of dharma. So, according to this, a person who treats everybody equally is acting according to dharma. So, this is how traditionally we look at justice. So, if you closely analyze the traditional view, the justice has got three attributes. The attribute number 1 is fairness, equality, and finally, it is impartiality. Now, fairness. Now, let us take fairness for the discussion. Fairness means absence of discrimination. Fairness is acting without bias, and as long as a person acts without discrimination and without bias is considered to be a fair person, and it is one of the important component of fair, justice. Next is equality. Now, equality, to explain equality, it has got 4 components, that is fair distribution of benefits among all stakeholders is important component of equality. Similarly, in the same line, the same equality should be shown in distribution of burden also, not only the benefits, burden also. Equals should be treated equally and unequals should be treated unequally. So, these are the 4 things which constitute equality. Then comes the final component, that is impartiality. So, impartiality is a hallmark of justice, where absence of prejudice is what is expected in idea of justice. So, prejudice cannot go hand in hand with the justice process. So, absence of prejudice has to be shown to establish impartiality of a person. So, these are the 3 important components of justice in a traditional sense. Now, say for example, if a teacher gives same marks for the 2 students, let us take an example of a test, a spelling test. A girl secures full out of out marks in the test, and she is not happy with that, because even in spite of scoring out of out, she got only star, but whereas the other girl who has scored out of out, but got a golden star. According to the child, she is being treated unfairly. because there is an absence of fairness, there is absence of equality, there is an absence of impartiality. So, this is how the traditionally justice could be understood, and the same understanding continued in many of the legal systems. In Magna Carta, that is a great charter in drafted in 1215, to no one will we sell, to no one will we deny or delay right or justice. So, that is how the traditionally we took up the understanding of justice, but modern view is quite different from the traditional view. The main difference is the dissociation of concept of justice from that of religion. For the first time in a modern view, justice is looked upon as a different altogether from the religion. So, what happens in a modern view? In modern view, the justice which was actually told to us through a system called as morals continue to remain with us, but now it has taken up a garb of a law. So, natural justice continue to remain with us, but in the form of legal rules, and these legal rules provide us justice. So, whenever a legal rule ensures a justice, it becomes legal justice, and that is what the modern view of justice. So, it is not a justice, a mere justice, it is a justice dispensed accordance with the legal rules. So, therefore, in the modern concept of justice, there are two parties, one is the right holder, another is a duty bearer. So, in the modern view of justice, there are 5 important components or characteristics. The first and very important characteristic of justice is it is secular in nature. So, religion has got nothing to do with it. Second one is the uniformity in justice, because the law prescribes justice and law ensures justice. Third, providing only the right is not enough, we need to have a remedy for that also. So, that is the third important component, that every right that is prescribed by a law, they provide remedy for it. The remedy can be of redressal of violated right, or it can be compensation for violating of a right. Then the fourth one is that the making of a law, enforcement of justice is going to be a prerogative of the state. The state is going to look after dispensation of justice. And the last one, the benefits, the punishments would be based upon the deeds of the each person only, and no other considerations should be taken into consideration. So, to make a final distinction between traditional and the modern view, traditional view is connected with religion, and it is giving each his due. Justice is a virtue connected with the religion, but whereas in the modern view the 5 components are important. So, there is dispensation based upon the act of the person, there is recognition of a right, there is existence of a law, and then there is a remedy to enforce the violated right. So, let us move on from the traditional and modern view understanding of justice to effect of this modern view on the system. So, here the effect is that the state is under the duty not only to make a law, it is under the duty to establish an effective mechanism to enforce those rights. So, that is the most important impact of the modern view. The modern view led us to believe that ubi jus ibi remedium, where there is a right, there has to be a remedy. A right without remedy, it is like an illusory right which has got no existence. So, the impact of modern view is establishment of an elaborate mechanism for enforcement of justice. So, under the modern view, the state is under different kinds of obligations. The obligations goes as follows. Outcome, so the state must ensure justifiable and fair equitable outcome of any act of a person, and to ensure such outcome they have to have a mechanism. This is going to be the second obligation, to build up a mechanism for justice delivery. Then after establishing mechanism, there has to be an effective and efficient judiciary to function and deliver the justice. Then along with the delivery of justice, there has to be a mechanism to make the law that facilitate access to justice, and then state also should provide additional kind of justices, which I am going to deal in the nearby slides. So, coming to next part of the discussion, that is access to justice. So, what we have seen now is that there is a need for justice dispensation by the state, that is the obligation created by the modern view, and one of the important requirement under the modern view is access to justice. So, now question is, what is access to justice? According to the jurist Upendra Baxi, access to justice is ability of a person to participate in judicial process. The question is whether that is actual definition or whether that is been, if that is a definition, whether that is been ensured by the state. So, traditionally we look at access to justice as providing courts, sufficient number of courts, and then providing assistance to the needy people to approach the court. So, that becomes the major functions of access to justice traditionally. So, therefore, traditional view of access to justice would be court, establishment of a court to dispense the justice, then providing access to such courts, and in case of difficulties providing legal assistance to such needy persons. So, if these three activities are performed, then the justice is ensured. This is what a narrow look at access part. But if you look at the access to justice, practically there are series of problems which a person faces. So, I have just made a list of the 6 problems which a person may face while accessing justice, but this list is not exhaustive, this is mere an illustrative list. First is economic capacity or incapacity. So, when a person is economically weak, he may not be able to access justice because justice do not come free of cost. You have to make court fees as a payment, and then also you have to hire a service of an advocate. That is the first hindrance. Second one is procedure of justice. The Indian courts follow a justice delivery system which the procedure is cumbersome and the delay would be unimaginable, and further it is a lot of time consumption is involved in this process. So, this time consumption is going to be the second biggest hurdle which a litigant has to cross over. Third one would be complex procedure. The complex procedure makes a people or the litigant not to follow the proceedings before the court. So, he would be at loss. As a result of that, he would be completely dependent upon the professionals who are assisting the parties to rely on them to provide justice. Then comes the legal representation. So, the legal representation is another problem which the needy persons face, as the legal representation comes with a cost. Then comes the important aspect of geographical factors. Courts are established at the headquarters, and a person living in a remote place Mofussil areas, has to travel all the way to the headquarters to fight the case. So, if you keep aside the litigation cost, that is court fees and fees to the advocates and additional fees, that is additional expenditure that is involved with other connected matters, the travelling itself would be another major expenses which a litigant has to undertake. Then comes the inadequate number of courts. As the population is increasing, correspondingly there is no increase of the courts. So, keeping these problems in mind, there has been continuous attempt made by the jurists to come up with a new method, a new approach to provide meaningful access to justice. So, I have classified these three processes into three waves of reforms. The first wave of reform was initiated by Capelletti and Garth. These jurists came up with the idea of providing legal aid. Now, legal aid is nothing but legal assistance. Then came the second wave, where the second wave was marked with the system of class action. Now, class action is where a person is not in a position to go to court and fight a case, a group of persons who are not in a position to fight a case, somebody else would fight for them as a class. So, this class action, to quote few examples, public interest litigation is the best example for this class action. Followed by, we have a provision in a civil procedure code of representative suits, that is also a good example of class action. Then comes a very important and the modern wave, that is the third wave, where the jurists, the legal systems, legislatures, everybody is encouraging the parties to go for ADRS, that is alternative dispute resolution systems. So, court should not be considered as the sole dispute resolution authority. The parties can take on themselves the burden of resolving a dispute by adopting negotiation, mediation, conciliation, or even arbitration as alternative process for resolution of dispute. So, therefore, the human rights movement of United Nations has actually expanded the concept of access to justice to the present date. So, earlier traditionally we looked at access to justice as providing legal assistance, but in the modern view the access to justice would be much more than merely providing assistance. So, the modern view of access to justice has actually increased the ambit of the concept of access to justice. Now, presently when we look at access to justice, it is not merely providing legal assistance. In addition to legal assistance, there is a provision for providing ADRS, alternative dispute resolution forums, and in addition to that there is going to be a third very important category which is a part of modern view, that is a new category of justice seekers. So, traditionally when you look at justice seekers, who are the people who want justice? The people whose rights have been violated. Now, take for example of a criminal law. Who can file a complaint? Who can go to court? Is the person who has suffered a crime against himself or whose rights have been violated. So, in other words, the rest of the world cannot initiate criminal proceedings for violation of somebody else's rights. It is the same person, the person himself, the victim himself has to continue with the criminal proceedings. Similarly, if you look at the criminal law, the whole edifice of the criminal law is based upon the rights of the accused. So, this is how traditionally we have come up with the development of criminal laws in India. What is the modern view is doing it to this traditional understanding of a criminal law? The modern view added one more justice seeker into the list. Other than the accused, there is a victim who is also in need of justice. So, the criminal law is now expanded to include not only the rights of the accused, but also a area of study called victimology. And so, the development of victimology and coinage for this idea of victimology is because of the modern view of justice. In addition to this, now there are some other category of justice seekers, like victims of natural or man-made disasters. So, these victims, they have no right against any other individual, but they are seeking justice against the state for the sufferings that they are undergoing. Natural disasters like tsunami or a tufan. So, these disasters can be the remedy can be provided through this modern view. Man-made disasters like Bhopal gas tragedy and questionably the Uttarakhand flooding. Now, these things are going to be considered under the new our modern view of justice. Then comes the final saying on this, that is intended harm committed on a person, unintended harm committed on a person, both have access to justice. That is the modern view of justice. So, when this is the modern view, wherein a person, there is a new category of people who are seeking justice. Now, we need to expand the mechanism to provide justice. So, initially we felt, or the system felt, that only court can dispense with justice, but presently we are coming up with the various other specialized authorities to deal with the disputes. So, now there is a justice delivery mechanism has expanded multifold. Along with the courts, we have special courts established to deal with special kinds of disputes. So, there is SC/ST atrocities court, which is specially established to take care of atrocities against SCs and STs, family courts to take up the disputes relating to the family, so on and so forth. Now, there are tribunals to take up highly technical disputes, like Telecom Regulatory Authority TRAI, that takes up disputes concerning telecommunication companies. Similarly, we have consumer redressal forums, which is may not be a highly technical one, but it is a special forum to look into the consumer disputes. Company Law Board, this is again a specialized agency to look into the disputes relating to the companies. So, in addition to these tribunals and special courts, we have informal mechanisms established, informal systems established by establishing mediation centers, conciliation centers, court annexed conciliation, court annexed mediation, etc. Unimpeded access to justice include free legal aid, which is the part of the first wave, class action, which is part of the second wave, alternative dispute resolution, which is part of a third wave of reforms. And then finally, we are having a new category of people who are looking into these kinds of requirements. At the end, I want to speak of a few concerns connected with these justice delivery systems. The first thing, we still have not reached millions of people whose rights are being continuously violated, but they cannot afford to seek redressal. Similarly, I do not have any hesitation to mention that the lack of access is nothing but denial of justice. Legal rights have become illusory because of this lack of access. So, the rule of law has become platitude because of this lack of access. And finally, this lack of access is leading to lack of public confidence in this public confidence in administration of justice. Thank you very much.